Prenups in Australia are created in an agreement called a binding financial agreement, or a BFA, which can be used by both married couples or de facto couples during their relationship to document what they want to happen to their assets in the event that they separate. Binding financial agreements are also used after separation to document the agreed property settlement, and can be used in estate and succession planning also to ensure assets are not diluted in the event of a separation. Without a binding financial agreement, the parties would need to seek orders from a court or negotiate an agreement between themselves, often involving lawyers. The notion that a prenup or binding financial agreement is not worth the paper it's written on comes up quite often these days, and the types of issues that may cause a binding financial agreement to be set aside by a court include where A. The agreement was obtained by fraud or non-disclosure of material matter, such as not including some of the assets of a party. B. Where the agreement was obtained under duress, for example, handing the agreement to a soon-to-be spouse 5 days before the wedding, or saying something like, "If you don't sign this, the wedding's off." C. Where one of the parties' conduct was unconscionable, where one party suffers a special disadvantage and that disadvantage is taken advantage of by the other party. For example, if the wife was pregnant and facing expulsion from Australia. Or D. Since the agreement was made, a material change in circumstances has occurred relating to the care, welfare and development of a child, which would mean that a party would suffer hardship. So what do you need to do? Make sure you comply with the legislation and do the following. Enter into the agreement early on in the relationship and make sure it is not close to the wedding or some significant date that would induce or pressure one or both of the parties into signing if they would not have otherwise done this. Ensure full disclosure is made and all assets of each party is listed in the schedule of the agreement. Make sure both parties have independent legal advice and plenty of time to negotiate the terms without any pressure. What the case law highlights as the pitfalls of not complying with the technical requirements of the Act and attempting to enter into binding financial agreements with anything other than good faith and candour. We can't predict the future. Your spouse may lose their job or have an emotional breakdown or perhaps a serious accident or illness and be unable to support themselves. In these situations, that party may have to have the binding financial agreement set aside so that they may seek a court order to gain a greater benefit from the asset pool if they were successful at having the agreement overturned. But in any event, it is better to follow the rules and have an agreement in place so that you have a roadmap to follow in the event of a separation when emotions are running high and can avoid legal fees. Keep in mind that in the event of separation, your estate planning will also need consideration.